Welcome back to the California Notary Public Course. Chapter 2, Part B, will cover now sections 5 through 10. In this webinar, we'll cover signature by a mark, certifying copies, immigration documents, protests, depositions, and confidential marriages. Please remember to record your start time for this module on your timesheet provided in your workbook. Let's move on. Here we have Section 5, Signature by Mark. A person who cannot write his or her name still can acknowledge his or her signature on a document or subscribe and swear to an affidavit by making a mark. To perform a notarization with a signature by mark, the notary public still performs the steps required for the appropriate notarial act, such as an acknowledgement or jurat. The notary public must use the appropriate form as well. The notary public must confirm the identity of the person making the mark by satisfactory evidence. The notary public also must perform the following additional steps in the next slide. If the signer is subscribing and swearing to an affidavit, the signer must make a mark where his or her signature should be in the presence of the notary public. Note that the mark does not need to be an X. Two witnesses must observe the signer making the mark and must sign their names next to the signer mark on the document. One of the witnesses must write the name of the signer making the mark next to the signer's mark. The signer also must make his or her mark as the required signature in the notary public's journal. The making of the mark in the notary public's journal must be witnessed by a person. The witness must sign his or her name next to the mark and write the name of the signer next to the mark. The notary public can serve as the witness for the signer's journal signature. The witnesses only are verifying that they witnessed the individual make his or her mark. A notary public is not required to identify the two persons who witnessed the signing of the mark or to have the two witnesses sign the notary public's journal. An exception, if the witnesses were acting in the capacity of credible witness in establishing the identity of the person signing by mark, then the witnesses' signatures must be entered in the notary public's journal. Here we have an example of a jurat. You can see where the name X and then the name Bob Smith was written in. On the next page, we'll talk about the journal entry. Here is an example of the journal entry for the jurat with a signature by mark. Under additional information, they've written in the signature by mark, and then under signature, the X has been placed, and Bob Smith's name was written in, and the witness name as well was Wendy DeWitt. Section 6, Certifying Copies. A notary public can certify the copies of only a few types of documents. The notary public only can certify copies of powers of attorney, copies of his or her sequential journal or portions of the journal in response to a written request of the California Secretary of State or a subpoena or court order. Certified copies of birth, fetal, death, and marriage records can be made only by their state registrar, by a duly appointed and acting local registrar during their term of office, and a county recorder. To certify a copy of a power of attorney, a notary public must compare the original power of attorney document and the copy to make sure the copy is exactly true and correct, or make a copy of the original power of attorney document, and then attach a notarial certificate to the copy stating that the copy is true and correct, and complete a journal entry. Here's a suggested form of notarial certificate for certifying a copy of a power of attorney as shown. I, the notary public, certify that on whatever date I examined the original power of attorney and the copy of the power of attorney. I further certify that the copy is the true and correct copy of the original power of attorney. You would sign it and then place your seal. The first part of the certificate, indicating in what county the notary public and person requesting the certified copy are located, is the venue statement. The venue statement establishes where the notary public performed the certification and where the person requesting the copy appeared before the notary public. The state is always California, since the notary public has jurisdiction only within California. The county is the county where the certification was performed. That is where the person requesting the certified copy personally appeared before the notary public and presented the original power of attorney for a certified copy. Since the notary public may provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public maintains his or her principal place of business, or the county where his or her oath and bond are filed, but must be completed with the actual county in which the notarial act took place. The notary public must insert his or her name and the day, month, and year. The person requesting the certified copy personally appeared before the notary public, and the notary public compared and certified the copy of the power of attorney. Then the notary public must sign and stamp the certificate with their notarial seal. A notary public must record the following details in their sequential journal each time the notary public certifies a copy of a power of attorney. The best practice tip is to ensure the completeness for a later request for information related to this type of transaction. The notary public should also record the name of the person who is requesting the certified copy, the name of the agent appointed by the power of attorney, and the person who signed the power of attorney, known as the principal. Time and date of the act. The type of notarial act performed was certifying a copy of a power of attorney. The fee charged for the notarial act. Here's an example of a journal entry. The date and time had been recorded. The type of notarization was a certified copy of power of attorney. Character and type of instrument, power of attorney. The name of the signer. Identity established by. The fee, and then the additional information. Copy requested by Bob Lohner, bank manager, First City Bank. It is recommended that this information be captured. A notary public can notarize the signature on a document affecting the immigration or citizenship status of any person. The notary public cannot assist the person in completing any immigration document except for the signature and date. Only an attorney, a representative accredited by the U.S. Department of Justice, or a person who is registered by the California Secretary of State and bonded as an immigration consultant under the California Business and Professions Code may assist the client in completing immigration forms. Only an attorney can advise a person regarding which immigration document or form the person should complete or advise how the person should answer questions posed by an immigration document or form. If a notary public is also a California registered immigration consultant, the notary public may assist the client by inserting the answers given to the consultant by a client. A notary public who is also a registered and bonded immigration consultant may charge $15 per person for completing a set of immigration forms. A notary public also can charge an additional fee for each notarial act performed in relation to a set of immigration forms. Please note that special rules apply to notaries public who are also immigration consultants or advertise their services in a language other than English. A notary public is barred from advertising in any manner whatsoever that he or she is a notary public if the notary public also promotes himself or herself as an immigration specialist or consultant. A notary public who is not a licensed California attorney and advertises notarial services in a language other than English must post with the advertisement, both in English and the other language, that the notary public is not an attorney and cannot give legal advice about immigration or any other legal matters. The notary public must also list the statutory fees that a notary public may charge for notarial services. In many countries outside the United States, an individual must be a duly licensed attorney before he or she may obtain a notary public commission. In Latin American countries, The phrase notario publico implies that the person is a practicing attorney in that country, which is not the law in the state of California. Under California law, a person may be appointed and commissioned as a notary public without being a licensed attorney. Therefore, a notary public cannot translate the term notary public as notario publico or notario into Spanish, even if the prescribed notice is posted. A first offense for a violation of this law is grounds for the suspension of the notary public's commission for not less than 1 year, or revocation of the notary public's commission. A second offense is grounds for the permanent revocation of a notary public's commission. Catherine Consultant is a notary public and has been registered and bonded as a California immigration consultant. Mikhail and Irina visit Catherine to obtain assistance in completing citizenship forms. Catherine's business cards say she is a notary public and an immigration specialist. Catherine enters information into the citizenship forms that Mikhail and Irina provide and enters information she knows from her own experience and education as an immigration consultant. For these combined services, Catherine charges Mikhail and Irene $100. Catherine has broken a number of laws. She cannot hold herself out as a notary public in her advertising because she is an immigration specialist. Catherine cannot enter information into immigration forms on her own, and Catherine cannot charge more than $15 per person for completing the forms on behalf of her clients. Catherine can charge an additional notary fee for any notarial services if she limits herself to completing the citizenship forms with only information provided by Mikhail and Irina, but can charge no more than the statutory $15 for each signature notarized. The permitted statutory fees are less than the total Catherine charged Mikhail and Irina. Section 8 Protests. The duty of a notary public on demand to protest the non-acceptance and non-payment of a foreign or inland bills of exchange or promissory notes is a nearly obsolete mechanism developed before modern regulation of financial transactions. Only those notaries public employed by a financial institution and in the course and scope of that employment are permitted to perform protests with regard to the specific financial documents described by California law. Because only notaries public employed by a financial institution can perform a protest in the course and scope of their employment, no fee is prescribed for the notarial service since it is part of the notary public service to the financial institution. Section 9 Depositions. When requested, it is the duty of a notary public to take depositions. However, a notary public cannot record and transcribe an oral deposition in shorthand unless the notary public is also a certified shorthand reporter and licensed by the Court Reporters Board of California. A notary public may take an oral deposition by writing it out in longhand or typing it out longhand on an electronic device. This may be awkward and cause confusion or misunderstanding. If a notary public is asked to take a deposition and the notary public is not a certified shorthand reporter, the notary public should inform the person asking the notary public to take the deposition that the notary public can take the deposition by hand in longhand or by typing the deposition in longhand, or the person may wish to contact a certified shorthand reporter to take the deposition. Generally, a deposition is a method of providing oral or written testimony under oath outside of a court proceeding. During an oral deposition, a witness who has been put under oath and answers questions from a judge or attorney or other officer of the court. In a civil proceeding, a deposition officer, who is a certified shorthand reporter, can put a witness under oath and record the oral deposition in shorthand for transcribing the shorthand record into a standard English language verbatim, written transcript of the questions and answers and other statements made during the deposition. Consequently, although it is a duty of a notary public to take depositions, a notary public is not necessary when a deposition is conducted. Section 10 Confidential Marriages. A notary public who is interested in obtaining authorization to issue confidential marriage licenses may apply to the county clerk for approval in the county in which the notary public resides. A notary public must not issue a confidential marriage license unless he or she is approved by the county clerk having jurisdiction. The county clerk offers a course of instruction which a notary public must complete before authorization will be granted. Additionally, in order for a notary public to perform the marriage, he or she must be one of the persons authorized under California law, such as priests, ministers, or rabbis. The county clerk in the county where the notary public resides may or may not approve the authorization to issue confidential marriage licenses. The county clerk should be consulted if the notary public is interested in obtaining approval. This concludes Chapter 2, Part B. Please do not forget to record your end time for this module on your timesheet provided in your workbook. We will now move on to Chapter 2, Notarial Acts and Procedures, Part C, Fees.